Anyone who says they have studied law, but they have not studied the Bible, they have not studied law. In Lecture 10, it's our hope that you're going to be able to understand the historical background of the amendments that followed the war between the states, specifically including the 11th through the 27th Amendment, and their generally intended purpose of expanding the authority and influence of the power of the central government. With Lecture 10, here's Jake McCauley.
We're going to go through the rest of the amendments tonight. We're going to start with the 11th Amendment. Now, I'm not going to read these amendments in their entirety. You can have those right in your notebook. You'll be able to see it. But I am going to expound upon them the best I can. We're going to keep it brief, but still hopefully leave you with a great grasp and understanding of each amendment. As we cover the remainder of the amendments, number 11 through 27, time will not permit us to effectively really get into these amendments enough or adequately. This is especially true of Amendments 14, 16, and 17, where these amendments have essentially transformed our representative republic into a democratic socialist tyranny. Your student manual contains vital details on these amendments and helping you understand how destructive they are. But it also talks about their lack of proper ratification, which is very important. We strongly recommend that each student take personal study time to read these sections carefully through after class and realize these truths need to be understood, exposed, and corrected if we are going to restore the constitutional republic that our founders handed to us. The states may not be sued in a federal court by citizens of another jurisdiction without the state's consent. This is dealing with lawsuits of states. This amends Article 3, Section 2, Clause 1, which did allow such suits. This resulted from a reaction against a lawsuit versus a state in Chisholm versus Georgia in 1793. The United States Attorney General, Edmund Randolph, argued the case for the plaintiff before the court. The defendant, Georgia, in this particular case, refused to appear, claiming that as a, quote, sovereign, a state did not have to appear in the court to hear a suit against it, which it did not consent to. Think about the power the state exerted at that time. Mostly because Chisholm versus Georgia, the 11th Amendment was ratified in 1795, which removed federal jurisdiction in cases where citizens of one state attempt to sue another state. Now, the 12th Amendment deals with the Electoral College. Article 2, Section 1 is to provide that electors should vote separately for a president and a vice president. So it just altered the Electoral College. Instead of voting for one individual, first place gets president, second place gets vice president. Now the Electoral College is voting for two separate candidates, one for each office. The 13th Amendment was where we find slavery being abolished. This was in 1865. The Emancipation Proclamation, just so that everybody knows this as a historical fact and a legal fact, this proclamation did not free slaves. It was the 13th Amendment and the ratification of that amendment that accomplished this. Congress shall have power to enforce this article by appropriate legislation. A very dangerous phrase. And of course, many people have different thoughts and ideas as to why that phrase was put in there in the first place. But one thing we do know, it gave Congress a lot more authority over states than had ever been intended to be given. This provision also appears in 14th, 15th, 18th, 19th, 23rd, 24th, and 26th Amendments. It has been used greatly to do what I just said, expand federal power and jurisdiction over states. The 14th Amendment has turned our Republican form of government on its head in many ways, usurping rights from the states and from the individuals. I'll explain some of that here, but your student manual has far more notes worthy of your reading after class. So please make sure to do that. The 14th Amendment deals with due process and equal protection. This particular amendment has turned out to be the most destructive of the powers reserved to the states. The states must respect the rights of all U.S. citizens, it states. There's nothing wrong with that. Of course they must, depending upon the status of that citizen. In other words, is he a lawbreaker? Is he a criminal? Did he come across the border illegally? There were grave problems with the ratification process of this amendment, and it's very important that you read through your notebook after class about those issues and those problems. If you're following along in our student manual, we're moving on to letter D on page 167, which says, "The states may not deprive anyone of life, liberty, or property without due process of law." The courts have subsequently ruled that liberty and due process include most of the rights guaranteed in the Bill of Rights, and that the Bill of Rights applies to government actions at all levels. This has been the justification for such actions as removing prayer and the Bible from public schools. Now, debate rages on whether the incorporation doctrine accurately reflects the intent of the authors of the 14th Amendment. However, original intent can be easily seen by looking back to the primary source writings. When Congressman Jim Bingham, a sponsor of the 14th Amendment, was asked if he feared that this might open the door to federal government encroachment on state authority, or take away or usurp the rights of the states, he replied, "I repel the suggestion that the 14th Amendment will take away from any state any right that belongs to it." In 1875, 7 years after the 14th Amendment was ratified, Republican Congressman James Blaine proposed a constitutional amendment. Now, this amendment was never ratified, but nonetheless, this Blaine amendment would have forbidden public funding of private denominational schools by the states. Note the similarity to the First Amendment. The proposed text of the Blaine Amendment read, in part, "No state shall make any law respecting an establishment of religion or prohibiting the free exercise thereof, and no money raised by taxation in any state for the support of public schools." Now let's compare that to the language of the First Amendment, which says, in part, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." Historically, the Blaine Amendment became pivotal in state debates on the role of religion in public education, religious establishment, and religious expressions. And if the original intent of the 14th Amendment was to actually incorporate the First Amendment, as well as the others of the Bill of Rights, into state governments, then this Blaine Amendment attempt would have been completely unnecessary. So now the federal courts have taken an extra step of authority within the state jurisdictions. Since municipalities and counties and school districts, of course, fall in that realm, then it trickles down and applies to even local school districts, which is why you see so many cases dealing with prayer and Bible reading and Ten Commandments and religious t-shirts and cheerleaders who want to have scripture verses at public school games, football games, basketball games, etc. The states may not deny anyone equal protection of the law. Those who aided the Confederacy, this is part of the 14th Amendment, those who aided the Confederacy in the South may not vote or hold office until pardoned by Congress. Also, debts owed to Union soldiers are valid, but debts owed to Confederate soldiers are invalid. Another example of stripping away the wealth of those that were a part of the Confederacy. The 15th Amendment was in 1870. This dealt with voting rights for former slaves. A U.S. citizen may not be deprived of the right to vote because of race, color, or previous servitude. The 16th Amendment birthed the income tax, or did it? The importance of this amendment cannot be overstated for many reasons, specifically because of the seemingly unlimited ability it gives Congress to fund programs contrary to the people and to the Constitution. But once again, time will not permit us to cover this topic in the depth that I feel that we need to, but your student manual does a very good job of that, so I highly encourage you to read through these notes in your manual after this lecture. But here is what I will tell you. Congress passed the income tax in 1893, but the Supreme Court ruled it unconstitutional in 1895 because of Article 1, Section 9, talking about no capitation taxes, no direct taxes from the federal government upon an individual. The way the states now got their money was by taxing their citizens, but the federal government could not directly tax. There was no capitation taxes. They could not directly tax an individual. They would tell the state, okay, Here's according to your population in the census. This is how much your part of the pie is to pay into the federal government. The states then would determine how they did it, whether it was through a state sales tax, maybe it was a state income tax, but that was left to the states, not the federal government. Congress passed the 16th Amendment in 1909, again, which was a new amendment, but dealing with the same topic of income tax. It was ratified in 1913. But there was ratification problems with the 16th Amendment. Bill Benson did the research on this, and his book is titled The Law That Never Was. There was other violations, and I'll let you read through the list of those, but there was more violations of this particular, the way that this particular amendment was passed. Skipping to page 171, letter E, for those of you that are following along in your student manual, we see the Sherman Antitrust Act. It was enacted in 1890, but the Congress enacted an income tax law that imposed a tax on the incomes of corporations in 1894. In 1895, we see that Pollock versus Farmer Loan and Trust, the Supreme Court declared the tax was unconstitutional because it imposed a tax on income derived from property. President William Howard Taft, in his message to the joint sessions of Congress in June of 1909, the president's message was published by Congressional Record in the Senate. He explained that the purpose of the function of the proposed 16th Amendment was to assure the constitutionality of his proposed Corporation Income Act, which was passed in the same 1909 sessions of Congress. The amendment did not authorize any income tax on a United States citizen. President Taft's message was that he called for a bill to impose a tax on only 2% of the income of corporations. Just 2%. That number has grown astronomically. 50 and 60% at times of people's income just from the federal side. He described his proposed corporation income tax billing as, quote, in the form and substance almost exactly the same character as the income tax law involved in the Pollock decision in the United States Supreme Court. So you can see here that in order to assure the constitutionality of the income tax on corporations, he proposed a constitutional amendment that would override the crux of the Pollock decision and thereby assure the constitutionality of his newly proposed 1909 Corporation Income Tax Act. You can read about the court's opinion on the 16th Amendment. In 1916, the U.S. Supreme Court held that the 16th Amendment created no new power of taxation. This was again in 1916. Other Supreme Courts have ruled on it. You can read down there. The capitation taxes are still forbidden. That has not been amended in Article 1, Section 9, Clause 4. This was understood to be a very limiting tax. In 1913, listen to this, the standard exemption was $4,000. That means in this day and age, if your corporation makes $60,000, if you as an individual corporation makes $60,000, you don't even file. That's in 1994 dollars. I'm sure that number has now grown in this day and age because due to inflation and the monetary system that we have now. Those making less, they didn't even pay a tax. No need to even file. That's your standard exemption. After deductions were subtracted, there was a tax on the first $20,000 of income. So that means that particular tax was on all the people that made over $60,000 in 1994 dollars, up to $300,000. You know how much that tax was? 1%. In addition, those who were very wealthy paid a graduated super tax. I want to talk to you about this super tax now. For those making $500,000 or more, which in today's dollar is for those making $7.5 million, the super tax was 6%. The federal income tax has served as a vehicle of tyranny where we fund the very tyranny that we despise. It's confiscating the people's money by a central government and returning it to the states in a manner that coerces the states to be an agent of federal tyranny. In other words, states, if you will not comply with federal standards, we will cut your wealth off. We'll cut that dole that you're on. We'll cut those funds going to your states. Where do those funds come from? The federal government now, in effect, according to the way that it's working now, by the coercion, we can see it clearly, has taken that money from the individuals of the states, put it into a federal system, and then bribes the state that the money came from in the first place. The 17th Amendment, 1915, as we move on here, and I know it's a hard topic to move on from, but we have to. 17th Amendment, at this particular point, in 1915, the senators were directly appointed by state legislatures, and when the state legislature felt the Senate was not representing the state government, the republic of that state, they would recall that senator and put somebody else in their place. But now we have popular elections. This has started to damage our republic because we are not a democracy, but nonetheless our senators now are elected popularly by the individuals in the states. This takes another power away from a state government, which we desperately need because that state government's power protects us from federal power. There were also horrendous errors in the ratification of this amendment, and they're written out for you in your student manual. However, they can be summed up by telling you about the amazing and shocking story that the executive branch, under the Secretary of State, acknowledged these errors and yet ruled they were immaterial. Now, it was clear that the proper procedure in proclaiming the adoption of the proposed amendment was not followed. Nevertheless, the Secretary of State was allowed to disregard the errors in violation of the ratification process, thus violating the very document they were seeking to amend, our Constitution. And yet, in spite of all of this, it stands today. Moving on to the 18th Amendment, which was the prohibition of alcohol. This amendment gave federal government authority over a matter of law enforcement that was better left to the states, or more importantly, family government. The powers delegated by the proposed Constitution to the federal government are few and defined. This is according to Federalist Paper number 45. Those which are to remain in state governments are numerous and indefinite. In other words, this was not a power designed for the federal government. This was a state government issue. The 19th Amendment was women's suffrage. The right to vote cannot be denied on basis of sex. This was already true in some states. Some states had already reversed this. The 20th Amendment dealt with presidential succession. So the president and vice president take office now on January 20th instead of March 4th. Back in the day, it took a while to move a president from Virginia or say he was from Georgia or South Carolina up to the D.C. area. Because of the improved transportation, it made an earlier date feasible and also reduced the opportunities for a lame duck president and congressmen to exert last-minute influence without an executive in office. Presidential succession altered again, and we discussed that in Lecture 6. The 21st Amendment was where the prohibition was repealed. Now notice the time. First, there was the prohibition of alcohol in 1919. Then in 1933, the prohibition was repealed. If you remember back with the 18th Amendment, it said in the wording in Section 2, the Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. So now we had to develop an agency to monitor to make sure that the states and the individuals, the citizens of those states, were not breaking this law by bootlegging and selling liquor, etc. So what was started was the IRS, was one of the agencies that had been started but was utilized to help enforce this, and also the BATFE, or the ATF now, as many people know it, the Bureau of Alcohol, Tobacco, and Firearms. Okay, we've repealed it, so we've said now that, there is no more prohibition on alcohol. However, the authorities that were set in play, the BATF and the IRS, that had authority in that particular law, dealing with that particular law, those authorities were never relinquished. So we said it's no longer against the law, but we kept the cops, if you will. We kept the law enforcement agencies that were in charge of it. Those should have dispelled as well, but they didn't, because federal government didn't really want to give up any authorities. Just because the law changed didn't matter. The authority was found in the guns, if you will. This is the danger, again, of these type of amendments that aggrandize federal power. Once that power is there, they don't like to give it back. The 22nd Amendment was the two-term limit for president. Now, the two-term tradition was broken by Franklin Delano Roosevelt during the crisis of the Depression and World War II. But when FDR died a few weeks into his fourth term in office, Congress decided to make the two-term tradition a rule with this amendment. The 23rd Amendment deals with the District of Columbia's electors. The D.C. now has electors in the Electoral College, equal to the number of electors of the least populous state. D.C. still has no voting representatives in Congress, but they do in the Electoral College. The 24th Amendment dealt with the poll tax. Poll taxes were usually $1 or $2, and you had to pay that in order to vote to help pay for the electricity or the different poll workers and things like that. But oftentimes it was used, especially in the southern states, to make it so that poor folks can't vote. And generally it was targeted because of your race. So this now made that illegal. The 25th Amendment was dealing with presidential succession again. It was revised. Go back to lecture 6 and you can kind of follow through how many ways it was revised. The 26th Amendment made it so that you had to be 18 years old to vote. Now, the right to vote may not be denied based on your age for anyone who is over 18. In other words, if you are 18 or older, you cannot be denied the right to vote. What it didn't do is it did not prevent states from setting a lower legal age to vote. You could be 16 and vote in the states. 18, it did not say you have to be 18 or older. It was just saying you couldn't deny anybody who was 18 or older. Voting is now increasingly seen as a universal right rather than a means of protecting rights and privileges to be exercised by those who can vote responsibly, by stakeholders, and those people that have skin in the game. We have so many people in our populace voting today because of a benefit they receive from a federal government, a benefit of which they never pay into. So that was why at one particular time it was only landowners that could vote, because the landowners were the ones being taxed. Those that didn't own land had no skin in the game. So you see now where a certain populace generally always votes for a certain particular political party. And why is that? Because of the welfare state that has been created and also aggrandized by that particular party. That also ended with the Congress shall have the power to enforce this article by appropriate legislation. Now with the 27th Amendment, you have congressional pay raises. This actually did limit the federal government. Very few of the amendments after the first 10, the Bill of Rights, limited federal government. Most of it expanded. No congressional pay raises will take effect until after the next election. In other words, I can't vote on my own pay raise. Now, this particular amendment was originally the 11th Amendment of the Bill of Rights, but it was not ratified by 3/4 of the states. And then, in 1992, the 38th state finally ratified it, making this amendment come to fruition. In other words, become an amendment to the Constitution, an official amendment. It sat on the table, but the director of the U.S. Archives has assured the United States of America that there is no reason why this amendment couldn't take 100 years to be ratified, and therefore it was ratified, and it's codified, and it's now our 27th Amendment. I'd like to thank you so much for taking part in this lecture of Institute on the Constitution's United States Constitution course.